Last year, the Australian federal government changed the law to make it legal for homosexuals and people to get married regardless of their gender. Was this constitutional or was this unconstitutional? My distinguished guest for this episode is once again Professor Augusto Zimmermann. He is the former Law Reform Commissioner at the Law Reform Commission of Western Australia, as well as a Fellow at the International Academy for the Study of Jurisprudence of the Family. Recipient of the Vice-Chancellor's Award for Excellence in Research at Murdoch University in 2012, and Editor-in-Chief of the West Australian Jurist, the yearly academic publication of the Australian Legal Theory Association. He'll be joining me in just a moment to explain and answer the question, is the new law regarding the undefining of marriage constitutional or unconstitutional?
Warning, you are now entering a diversity zone where different opinions are tolerated. This is not a safe space. This is Pellowe Talk.
Welcome to the show, Professor Augusto Zimmermann. How are you today?
I'm very well. Thanks for inviting me again, David.
My pleasure. Thanks for coming on again. Now, at the end of our last interview just a week ago, which I haven't even posted yet, but I will as soon as possible, and maybe this one will be able to follow hot on the heels, we ended up talking off camera about the legality or the constitutionality of the federal government's new legislation about undefining marriage. I'm claiming I've coined that word. I haven't heard it anywhere before, and I haven't seen it anywhere since I said that, but I don't think they redefined it. I think they just undefined it and totally stripped it of any significance or meaning altogether. Tell me, is it unconstitutional, the redefinition of marriage that they did through the legislation passed at the end of last year?
Well, I have exposed this problem. I was even approached by the Senate inquiry on the subject of same-sex marriage last year in Sydney. I think some of these people thought I wouldn't be able to attend the inquiry because it was held in Sydney, and I'm based in Perth. But I had the opportunity to actually visit Sydney, and I was there, and I then attended the inquiry conducted by the Senate. And I was very clear, not only at that particular point in time, but also in my own submission, that I believe there are major problems regarding the constitutionality of the redefinition of marriage. And I can explain to you the problem. And it's not so easy question to discuss because I'm just following what the High Court has previously explained and dictated through the precedent. So I can explain to you and to your listeners what the problem is. Well, the problem is that originally the High Court had one particular method of interpretation that was called originalism. And that was the method adopted by the High Court over the first 20 years of its existence. The High Court originally was comprised by members of the convention. For instance, Samuel Griffith was one of the leading politicians who attended this convention. Others like Edmund Barton and others had the same approach taken by the then Chief Justice of the High Court, namely to say that the Constitution should be interpreted in accordance with the original meaning, which is the meaning intended by the drafter of the document. But this was the main approach only until the 1920s, when we had the notable or notorious, depending on your point of view, shift in the methods of interpretation adopted by the High Court. The High Court decided that rather than using the originalist approach, it should then adopt what is called literalism. And literalism is to interpret the Constitution according to the literal meaning of the word as it was expressed in a dictionary at the time of the law being enacted. As you know, the meaning of marriage in 1901 was very clearly the union between a man and a woman. So if you adopt this, what is the now orthodox method of interpretation, the High Court would have no other option but to declare the amendment to the Marriage Act as constitutionally invalid.
So let me just repeat or clarify, confirm back what I'm understanding. In the first 20 years of Australia's federation, the High Court had a method of deciding what was constitutional and what wasn't, which was called originalism. And they had a very good idea of what the original intent was of the framers of our Constitution, because many of the framers of our Constitution then served on the High Court. Is that much? Okay. So then what happened was they switched to literalism, where the dictionary definition, the common understanding of any given word at the time of the framing of the Constitution, the turn of the century, 1901, that was now the new approach, as opposed to trying to read the minds or the original intent of the framers of the Constitution. Is that much right so far?
Well, the three first members of the High Court were all members at the convention, so they knew exactly what they intended to, and they wanted to do. So the method of interpretation they adopted is basically one being faithful to the spirit of the document. Unfortunately, this method was changed in the 1920s by a person who was on the losing side of the debate, namely Sir Isaac Isaacs. Sir Isaac Isaacs was actually a member of the convention as well, but he happened to be a centralist and not a federalist, and he basically was on the losing side in every single important debate at the convention. But of course, once he became the justice of the High Court, he realized that he could overcome his defeats by imposing a different method that is not necessarily the most faithful to the intention of the drafter. But in saying so, I must add that even the literalistic method is not helpful to the advocates of same-sex marriage being
is the literalist approach
by means of legislation.
Is the literalist approach still the method that's being used in the High Court today?
Well, some people say that I would guarantee to you that's the main method. But there is also the originalistic method that is, in my opinion, the best method that should be adopted. But look, it really doesn't matter. It doesn't matter, because if you adopt any of these existing methods, the outcome would be the same. Is there
a third option? Would the High Court have to rule that the new legislation, by ignoring or tossing out the definition of the word marriage as it was in 1901, or presuming the right to materially change it, or is there a third option? Could they come up with some other approach?
There is one option, that is to be unfaithful to both the literal meaning of the word and to be completely disrespectful of the intention of the legislator by adopting what you want through the method which is called the living constitution, which is to adapt the constitution to the changing needs of the so-called changing needs of the society, as individually perceived by the judge or himself or herself. So that is for instance, what Michael Kirby advocates. That is the living constitution approach. So, in this sense, it's possible to distort the meaning by saying that the we live in a more evolved age, or we are better than them, and might makes right after all. Not that rights are inalienable of the individual; they're not God-given, but they are given by the judges, unelected judges. That's what the Supreme Court of the United States did when they declare that they are gods by saying that same-sex marriage is now to be considered a fundamental right. Well, the idea of fundamental right is connected with a natural law tradition of God-given inalienable rights. So it's right to life, liberty, and property, and perhaps even the pursuit of happiness. Not that you can be happy, but you have the right to pursue happiness. That is the right derived from the fact that, according to a Christian tradition, we were created in the image of a benevolent God.
That's right.
That's what the drafters of the American Declaration really believed. And that's why we have this idea of inalienable rights and separation of powers. What the Supreme Court of the United States has done is to undermine separation of powers by imposing their will in this regard of the structure of the Constitution. So there is no longer federalism in the country. There is no longer protection of inalienable rights. And the High Court can basically say that people are not enlightened enough to understand that same-sex people should have such a right given to them.
I'm interested in what the counter-arguments are, and I don't have a guest on at the moment, but I assume you're familiar with the arguments that you disagree with. But for want of a better term, I'd like to invite you to play the devil's advocate. If this came to the High Court of Australia and you were to defend the government's legislation, and somebody came against you and said, no, this is unconstitutional because when the Constitution granted the government to make laws regarding marriage, in no way was that ever foreseen originally or literally as power to make laws regarding the relationships between homosexuals or opposite gender, anything other than opposite gender, traditional relationships as defined in that age. How would you, if you were, some of the people you would criticize and disagree with, how do you think they would argue for the constitutionality of the law that was passed in December?
Well, I think I would just say that their understanding of the matter is a result of the poor quality of legal education in this country. Certainly, they are adopting a very narrow legal positivistic approach by basically saying that the opinion of judges in particular cases when they can actually select the cases of their preference in order to elaborate on a theory of precedent, they are going to say that this is more important than the spirit of the Constitution or the intention of the lawmaker. Well, it depends on the worldview that you adopt as for the interpretation of the law. So if you believe in judges dictating the law or being lawmakers, then you believe that what judges have decided is more important than the law itself and the real intention behind the document. And if you think about what the common law tradition initially established, is that judges are not creators of the law, but they are actually discoverers of the law. And the law are based on principles that have to be respected. And certainly one of the principles of hermeneutics is to respect the spirit of the law and the document by taking into account what is the intention of the drafter. I think when precedent, for instance, departs from the original meaning, it should be overturned. The judge should have the boldness and the courage to say that they made a bad decision and correct the problem as a matter of urgency.
Amen. Preach it. I agree. It's some courage and conviction, some spines to overturn bad law is definitely needed right around the Western world. And I'm sure we could think of many examples and maybe indulge the legal nerds and talk about them a bit later. But,
yeah, and can I give you another thing that's quite interesting? Is the fact that I'm sorry to interrupt you, but this is quite an interesting discovery that I made. One of the first instances of a living constitutional approach was adopted in the notorious Dred Scott case. That's the case of slavery in America. That's when the judges considered that, derived from the right to property, there is a right of the slave owner to keep his property if he had, for instance, to move from a jurisdiction which allowed for slavery to another one that slavery was forbidden. Since he would then have guaranteed through the Fifth Amendment the right to keep his belongings or his property being preserved, then he saw that this would extend to the ownership of over another human being. And that's when you had the first ever application of what now the left uses as the substantive due process principle. And that's the same rationale that was adopted in the early 1970s in the notorious case of Roe versus Wade. So basically the same argument adopted to the outcome being delivered in 1971, if I'm not wrong, that was Roe versus Wade, was the same rationale that had previously been used in the middle 19th century to the notorious Dred Scott case that ultimately led to the constitutionalization of slavery in the United States. And I would even go further and say this is the main cause of the Civil War. So if you have to think about the Civil War in America, perhaps the main culprits of the war, of the outbreak of the war, is this American Supreme Court, which was unable to resolve the matter, but rather constitutionalized the institution of slavery. And that was what triggered the Civil War.
Just run that by me one more time of exactly how the dreads. I'm not sure I quite got that.
Well, yes. If I'm not wrong, this Dred, and I might be wrong, it could be Mr. Scott, was a slave.
Okay.
And he wanted his freedom given to him because his owner, the slave owner, was in the process of leaving his estate, and I don't remember the name of the state, but it was a southern state in the south of the United States, which of course would be part of the Confederation, the Confederate States. And this person was then moving into another state where slavery was not an institution. So this person decided that he would request his freedom as a result of the fact that the other jurisdiction didn't authorize people to have slaves as their properties. And the result was that you cannot lose property without due compensation and without due process of law. So the decision of the court is that the property rights of the individual are considered to be a fundamental right of the individual. But the decision to be made in this regard is the same as ignoring the natural law foundations of the concept of inalienable rights. So basically, what's her name? Taney, the justice of the Supreme Court, decided that natural law theory had to be thrown under the bus, basically saying that he wouldn't regard the need to interpret the Fifth Amendment according to natural law theory, which is basically the main theory by which you should interpret any provision of the American Constitution, because that was the philosophy adopted by the American founding fathers. So he said that he didn't believe in natural law theory. We are now evolving. the Confederates even adopted the first idea that the Constitution was an outdated document because, after all, Darwin had proven that not everybody is equal, that there is a difference between the races and things of this nature. So the 19th century triggered this idea that racism could be scientifically justified, so that the whole idea that we are born equal and created by by God with equal rights, created in the image and likeness of God, all these things were considered to be disproven by science.
So the main problem with the Dred Scott case was that the High Court basically denied or ignored natural law, and they started going with positivism as opposed to natural law. Is that the main problem with their decision?
It is one of the main problems with that decision. Another one is to think that you can update the Constitution because society sees the Constitution as an old-fashioned document, but better even saying the judges regard the Constitution as in need of being reinterpreted. So what I tell you is that when these kind of things happening, you might even agree with what judges do because you happen to be perhaps a lefty, progressive person who thinks that it's good to have judges really interpret the Constitution not in accordance with the traditions of the common law, but according to the ideology of the interpreter of the document, the applicator of the document, namely an individual judge. But this is a double-edged sword because the Nazis thought that they were highly progressive. And when I say I have written a book called Western Legal Theory, I have a chapter on National Socialist jurisprudence. And it's quite remarkable to see that the Nazis believed very firmly in the concept of living constitution and the Constitution as evolving document. And they thought they were being very progressive in doing so because they based their idea in according to them, the latest discoveries of science. But of course, science in this case would be later on proven to be completely incorrect.
Yeah, of course.
But they thought they were...
As it so frequently is.
Yeah, but in many ways, the whole rationale behind, for instance, preserving the Weimar Constitution, that was the constitution enacted between the First and Second World War, is that there is no need to repeal the document or to create another constitution because it could simply reinterpret the Constitution according to the evolving needs of the society. In this particular case, as perceived by the leadership of the Nazi Party, people such as Hitler and Goebbels and Goering and so forth. So that's why I believe this idea of living constitution is a double-edged sword. Normally people who like it is just because they tend to be in agreement ideologically with the judge. But let's see if they get a Nazi judge to see if they would continue to agree with the idea of living constitution. It's just because they like the ideology and they agree with the outcome of the case, even though this is a prostitution, if I can say, of the tradition in the West of separation of powers, even democracy, and even the idea of the rule of law itself. That's not the rule of judges, as I had said before to you. It's the rule of law, after all. It's not the will of unelected judges that should prevail. Yeah,
I know what you mean. There's quite often a prevailing sentiment in people that I argue with, that the need to overrule people assumes that the people who are overruling my personal liberty are making a good decision. So, for example, with parental rights, I would argue that I have the natural and transcendent right to instill my values in my children, and I don't care what the government's values are. They have absolutely no authority or jurisdiction in my family home over what my children are taught to. And that extends naturally to their education. They have no right to educate my children beyond the fundamentals necessary for a profession such as reading, writing and arithmetic, and transgress into my rights and my responsibility such as values. But what people fail to understand when they disagree with me is that they're empowering Malcolm Turnbull to educate their children, or Daniel Andrews, or Bill Shorten. And what they're gambling on is that 10 years from now, 20 years from now, 50 years from now, this methodology of saying parents don't have rights, the majority by government or the government by majority has the rights to educate your children. And my question to them is, how do you know that Malcolm Turnbull's got it right, that Bill Shorten's got it right? How do you know that the majority has got it right? And this method of reinterpreting natural rights and changing them whenever it suits your agenda because you disagree with the decision somebody might make with those natural rights is just a fundamental violation of basic social liberty.
Mm-hmm. Well, you are preaching to the pulpit. Yes. So I would say, yeah,
a bit of a mixed metaphor. They're preaching to the choir or preaching to the converted, preaching from the pulpit, maybe. But that's okay. We've got to forgive you.
Preaching from the pulpit, then.
Yeah, preaching from the pulpit. We'll pretend that's what you said.
Look,
I love your Brazilian Australianness.
Yes, but it's. I feel sometimes I have to be lecturing on common law history to the people in this country because they receive no education in legal history. So when you say about parental rights not being protected, that's certainly in violation of the common law, of the principles of the common law, because if you read the works of the greatest common lawyers in English history, the sorts of or the likes of Blackstone, for instance, William Blackstone, mm-hmm. or perhaps Bracton, or certainly the greatest common lawyers who established the now widely regarded and accepted leading principles of the common law, parental rights would be included in these fundamental rights. I mean, for instance, I can refer to the work of Emeritus Professor William Wagner, who has written a very comprehensive paper in the Western Australian Jurist exactly about parental rights being considered a natural right of the parent, mm-hmm. and receiving, historically speaking, due protection of this right by the law. But even international law would protect parental rights. So if you happen to be a little bit less conservative and you decide to rely on such things as international law, there are plenty of conventions stating that parents have the rights to the priority in education of the child should be provided by not the state but rather parents. The state is not the main provider of education; it's actually the parent. Mm. And that is stated in several international law, human rights legislations or laws. For instance, the International Convention, the Rights of the Children, certainly the International Civil and Political Rights Convention in the 1960s, certainly the UN Declaration of Human Rights. So all these things prove one thing that's for sure. If the Australian government has signed such documents and is not respecting the rights of parents to provide, for instance, education to the kids according to their own religious beliefs, that it means it is as simple as that the Australian government is in violation of law, of the international law. It's in violation of the common law tradition and is certainly violating international human rights law. So the Australian government is acting illegally by interfering on the rights of the parents to better educate the kids according to their own religious beliefs, religious or beliefs in general. It could be non-religions as well. One thing that might be also regarded as a totalitarian approach is this whole idea of adopting what the Liberal Party seems to like so much as well. Not only the Labour Party, the Liberal Party seems to have an appreciation for this idea of national curriculum. That is a totalitarian idea, because if you control the curriculum, then you control the minds and hearts of the kids.
Yep.
When I was dealing with this matter of being invited by the Institute for Public Affairs to write a chapter on this subject of the history curriculum, I realized that the curriculum was drafted by a notorious communist. And it's not that we would call him as such just to, call him names. And because for me to be called a communist couldn't be a worse insult, in my opinion.
Right,
I think
agree.
in many ways it's as bad as to be called a Nazi, because both the same, perhaps the communists killed even more people than the Nazis.
That's right, yep.
So, but this guy was a member of the Communist Party.
Wow.
He was a member. And he has, in this curriculum, stated about the wonders of Islam, and has basically watered down the contributions of Christianity. For instance, there is a topic for discussion saying how bad Christianity has been for the West in terms of bringing about such things as the Dark Ages, for instance, or what the Crusaders did that was so terrible according to this history curriculum.
Yeah.
But about Islam is just about the enlightenment provided by Islam, how great Islam has been, and the great things Islam has done for the West.
And that's part of our national curriculum?
And communism, there's basically nothing. If there is a reference to communism, it's just about, for instance, that what they did was not in accordance with the teachings of Marx, that, real communism has never existed, and so forth.
That's, well...
By the way, I have something to tell you. Do you know that the concept of human rights was invented by the United Nations according to the national curriculum? So we didn't have such a thing as human rights. Mm-hmm. Certainly this professor of history doesn't read history books to know that we had the American founding fathers talking about things such as inalienable rights. So basically he thinks that human rights is a creation in the 20th century, which was the most murderous century in the whole history of mankind. Yeah. So he thinks that human rights was created in the century that brought more than any other century so much misery and pain to humanity. Yeah.
Well, that was meant to be a response, an acknowledgement of the pain and misery, not a cause, but a consequence of that, well, particularly World War II, wasn't it? The 1948.
I have written also for the IPA. The IPA review an article proving that the United Nations has caused more problems for the protection of human rights than the benefits for the concept of human rights.
Interesting.
Because, for instance, the Human Rights Commission of the United Nations was hijacked by highly oppressive regimes, including Libya. To have an idea, the president of the Human Rights Commission was a representative of Gaddafi's Libya.
Wow, that's terrible. The United Nations is utterly corrupt, broken, and a failed bureaucracy. The world would be certainly better off if they just disappeared overnight, and we'd all save a lot of money propping up unelected bureaucrats telling us how to run our country.
Yes.
So, look, to bring this back to marriage, in your opinion, the High Court must, if they have any respect for the Constitution or the law, if it were to come before them, they must uphold that, or they must invalidate the legislation that the government passed regarding the undefinition of marriage.
Look, I teach constitutional law, and I always tell the students, you have to give me two opinions. Mm-hmm. And I'm very countercultural and heterodox in my approach.
Good.
because I say, give me what you think the court is going to do, and then you tell me whether you agree with what the court is doing. Mm-hmm. Because what's happening now in this country is that we just worshipping judges rather than, just having a critical approach. I mean, one thing that's happening as a result of the long march through the institutions is that once the left took over all these institutions, including the judiciary, including academia, now we are stopped to have the right of dissent. So basically, if you think that something is wrong, you will be ostracized, and you are going to perhaps even perhaps having the risk of losing your job, or even being persecuted by your peers. And so when you ask me this, I would say to you that there is no such thing as a final decision on this matter, because the High Court in the past has had some conservative judges, such as Sir Harry Gibbs, for instance, saying that the marriage should be defined according to the literal meaning of marriage in 1901. That's when the Constitution was enacted. But you can also go to the originalist approach and things like that. So in a certain sense, constitutional interpretation is a mysterious terrain. It's not something that's for the average citizen to be able to more comprehensively understand, and that's what makes it so mysterious, and at the same time can allow judges to have such a margin for creative interpretation. Because when they say to you that they are just interpreting the Constitution, they are not telling the truth. They're not telling the whole truth, because there are so many methods available. When it comes to interpreting a normal statute, as I have told you before, we have to consider the intention of the drafter, because that's what the Acts Interpretation Act basically dictates. It's actually determining that the method needs to be respectful of the drafter's intention. But when you talk about interpreting the Constitution, judges can basically lie or not tell the whole truth. Let's be kind to judges. They are not lying. They're just not telling the whole truth. Okay. Because to say that the Constitution is being interpreted according to perhaps even a particular method of interpretation doesn't tell you anything. Because there are different methods. You can combine them. You can, for instance, even if you want to reach a particular outcome, ignore the method you have been so far adopting and adopt a different one. For instance, the federal structure of the Constitution have written a paper for the CIS that was published in Policy magazine, explaining that rather than being the revisionist approach or the living Constitution approach, the main source of, I would say, distortion of the federal nature of the Constitution was provided, or is derived from the literal approach rather than the originalist approach, because the Bible is very clear about the letter killing and the spirit reviving. So certainly if you interpret provisions so literally and in disregard of the context, you might actually kill the document by taking passages of the document out of context and adopting a more heterodox approach. So that's how the original distribution of powers amongst the Commonwealth and the states has been basically obliterated. And in many ways, the federal system in this country is being undermined. That's a result of the interpretations of the High Court that have expanded the powers of the Commonwealth.
Let me just ask you then in closing to, as you do with your students, give me two opinions. What do you think the High Court should do if the case was presented that the law redefining marriage was unconstitutional? And what do you think they will do?
Well, what they should do, good, because then I feel a bit like my own students. And that's good. So what I think we should do I think they should remember what Justice Frankfurter of the Supreme Court of the United States said in the early 20th century. And, this is actually good for them to do because they like so much to be inspired by foreign jurisdictions. So I'm not giving them the inspiration of getting inspired by the Supreme Court of the United States. Justice Frankfurter was very clear when he said that the final touchstone on matters of interpretation, constitutional interpretation, is the document itself, is the Constitution, the written text of the document, of the Constitution. Mm-hmm. So I think what they have to do is really to have a thought and consider whether they have been applying the document and interpreting it in a proper manner. So that's the advice I would give. And then if they want to really be inspired by a revisionist judge that I have mentioned at the beginning of this conversation, namely Sir Isaac Isaacs, he was very clear when he said that it's better to be finally right than to be consistently wrong. So I think what they have to bear in mind is that if they are wrong, they shouldn't be consistently wrong. They should finally get things right. And so what I ask them is to remember what Sir Isaac Isaacs explained in the 1920s when this method, that's now the normal method adopted by the High Court, was developed by him. Better to get it finally right than to be consistently wrong. And another thing is that there is nothing that creates binding precedent when it comes to these matters of same-sex marriage, because the ACT case was dealing with the territorial law of the Australian Capital Territory. They have mentioned en passant, which means it's just an obterdictum. It doesn't really create binding precedents, not binding. That the court perceived the need perhaps to adopt a different approach. But this is not something that they have to necessarily have to rely on this, because there are other instances of opinions manifested by previous judges of the High Court that could lead to an entirely different outcome of the matter. So it's still open to interpretation. But as you know, judges might sometimes not be so bold enough to be challenging the current trend. Yep. And I think the main responsible for the whole mess that we are facing now is that hopeless former Attorney General called George Brandis. I don't really know what England has done to deserve such a fate, to have to bear Brandis over there. Because Brandis, to be blamed, he is the responsible for the fact that the constitutionality of this issue was not discussed. When I raised this issue at the Senate inquiry, the senators were absolutely quiet on that, perhaps acknowledging my authority as a constitutional lawyer and not having the capacity to defy my arguments.
Well, so I think the explanation for Brandis heading there is a bit of karma, that we're sending our lawless citizens back to a penal colony.
I think they have thought, well, England has so many bad politicians there, and perhaps one more, one less is not going to make such a difference. We are going to export more bad politicians to England. They have plenty of them around.
Professor Augusto Zimmermann, it's always a pleasure hearing you expound the virtues and nuances of Australian and international law. Thank you once again for joining us on Pellowe Talk.
It is a great pleasure, David. Good to talk to you.
Thank you. Well, that's Pellowe Talk for this episode. I hope you enjoyed that. If you've got opinions, thoughts, comments, I'd love to hear from you in the comments beneath this video. Let me know what you think. And just in case you didn't know, YouTube has completely demonetized every video in my account. This is a case of big corporate censorship trying to make it impossible for tellers of truth to make a living from doing it. And it's just ridiculous that somebody like that would suggest that advertisers might not want to be seen adjacent to controversial or difficult subjects. I mean, 60 Minutes in every nation has advertising between different stories on difficult and controversial topics. So the suggestion that they can't sell advertising in that space is utterly ridiculous. But what it does mean is that, as always, Pellowe Talk and the rest of the alt media community is entirely dependent on being viewer funded. And you can make a one-off donation or be a regular contributor for as little as $3 a month at davepellowe.com/donate. I really appreciate my partners who are keeping this coming to you. And if this content has been useful to you, I'd ask you to consider supporting the ongoing production and this mission of telling truth to culture. But that's it for this episode, and I look forward to seeing you in the next one.